Chair, we now continue line-by-line scrutiny of the Crime and Policing Bill. Minister.
Thank you, Mrs Allbuck. And just to recap, we're on clause 102, and I just started to set out that the Home Office had consulted extensively on the measures for reform around confiscation orders, and not only had we consulted extensively on those new measures that were suggested by or recommended by the Law Commission, but we'd also had the benefit from over 20 years of operational insight. And these reforms that were being put forward will support the delivery of key objectives endorsed by the Government in the Economic Crime Plan 2 to reduce money laundering and increase asset recovery returns to ensure that criminals are deprived of their benefits from crime. These wide-ranging reforms are introduced across 12 parts in Schedule 14 in relation to England and Wales. The provisions in Schedule 15 largely replicate, with appropriate modifications, the reforms for Northern Ireland. I do not propose to go through the whole of Schedule 14 part by part, much of which contains necessarily very technical provisions, but I would be happy to explain particular provisions if any honourable member would find that helpful. Turning next to clause 103, this introduces cost protections for enforcement authorities in the High Court and in Scotland the Court of Session in civil recovery proceedings under the Proceeds of Crime Act 2002. The Government is concerned that the current rules that govern how costs are awarded in civil recovery cases expose enforcement authorities to the risk of excessive strains on their budgets, particularly in cases against wealthy individuals who use very expensive legal teams. Even if a law enforcement agency applies for a civil recovery order in good faith and in the public interest, losing a case exposes enforcement agencies to paying substantial legal and court fees. Enforcement authorities work to make decisions in the public interest, and it is detrimental to the protection of the public if authorities are deterred from pursuing an investigation for fear that if any resulting legal action is unsuccessful, they would face adverse costs and expensive litigation. Clause 103 therefore amends the so-called loser pays principle to ensure that the court does not make an order for costs against an enforcement authority unless the authority has acted unreasonably, dishonestly or improperly during the course of proceedings, or it would be just and reasonable to make such an order against them considering all the facts of the case. Cost protections will provide a positive step forward for the UK's broader goal of recovering criminal assets and disrupting criminal activity. And I commend these clauses to the committee.
Thank you. Clause 102 of the bill introduces reforms to the Proceeds of Crime Act 2002, aiming to clarify and strengthen the confiscation regime for proceeds of crime in England and Wales. Schedule 14 outlines several significant amendments with the primary goal of improving the effectiveness and fairness of confiscation proceedings. One of the key changes introduced by Schedule 14 is the insertion of Section 5A into POCA. This new section provides an overarching principal objective for the confiscation powers under Part 2, which has been previously lacking. The principal aim, as defined in Section 5A2, is to deprive the defendant of the benefit from crime within their means. This will help ensure that confiscation powers are used proportionately and in line with the objectives of the law, addressing gaps in case law and providing a clear framework for the court. Paragraph 2 of Schedule 14 now allows the prosecutor to decide whether to pursue a criminal lifestyle assessment rather than automatically applying it. This change allows for more flexibility in the application of these provisions, enabling prosecutors to allocate resources more efficiently and only pursue the criminal lifestyle route where appropriate. Paragraph 4 introduces a change to the test for determining whether an offence constitutes part of a defendant's criminal lifestyle. Previously, the law required at least 3 offences to qualify, but the new amendment reduces this threshold to 2 offences. This will also apply if the defendant has benefited from or intended to benefit from the criminal conduct involved in the offence, making the test easier to meet and broadening the scope of the confiscation regime. A significant reform is found in paragraph 6, which amends Section 7 of POCA, clarifying how the value of the recoverable amount should be calculated. Currently, certain categories of property are ignored when calculating the value of a defendant's benefit from crime, including property that has been forfeited or is subject to a recovery order. The proposed amendment extends this to further categories of property, such as property seized under any rule of law or property returned to victims. This ensures that the confiscation amount reflects only the actual benefit derived from crime and prevents double counting of assets that have already been returned or forfeited. In light of the changes introduced in Clause 102 and Schedule 14 regarding the criminal lifestyle provisions, can you clarify how the new flexibility in prosecutorial discretion will ensure that limited resources are effectively allocated while also safeguarding the fairness of confiscation proceedings for defendants who may not meet the criteria for a criminal lifestyle? Clause 103, subsection 1, inserts a new section 288A into Part 5 of the Proceeds of Crime Act. This provision aims to protect enforcement authorities from being ordered to pay costs in civil recovery proceedings conducted in the High Court. The Court is prohibited from making such orders unless the enforcement authority acted unreasonably, dishonestly or improperly during the proceedings. New section 2881A1C introduces discretionary power for the Court to determine if, in unforeseen circumstances, it would be just and reasonable for an enforcement authority to pay costs. This provision acknowledges that civil recovery orders, which result in the permanent deprivation of a person's property, engage the right to peaceful enjoyment of possessions. It ensures that the enforcement process complies with the right to access to a court, as guaranteed by Article 6 of the European Convention on Human Rights. I'd be grateful if the Minister could tell us what mechanisms will be in place to ensure that enforcement authorities could be held accountable if acting unreasonably, dishonestly or improperly during civil recovery proceedings.
Well, can I thank the Minister, because I think he went into some detail there about how Schedule 14 actually operates. I did just want to refer to this issue around criminal lifestyle offences, which is in Schedule 2 of POCA, which is around where the court utilises to determine whether a defendant has a criminal lifestyle. And this is about what we are adding in terms of the changes. And this refers in particular to the two environmental offences, depositing certain waste otherwise than in accordance with an environmental permit, and also operating a regulated facility or causing or knowingly permitting a water discharge activity or groundwater activity otherwise than in accordance with the environmental permit. So the third offence we're adding is another one, which is the keeping of a brothel for prostitution. So I just wanted to make clear that those are being added in. In terms of some of the references that the Minister, the Shadow Minister made in terms of how this will be kept under review and whether there will be unreasonable measures being introduced, it's my understanding that obviously the legislation will set this out, but there will be, the courts will still have a role to play in any measures that are deemed to be unreasonable and forming a view about that. In terms of anything else, because it is very technical, this part of the schedule, I'm very happy to put in writing to him any further information that I haven't been able to answer now. But I think the general view is this is implementing the recommendations from the Law Commission. As I understand it, it's very similar to what the previous government were going to support. So on that basis, I just want to commend the clauses to the committee.
Yeah. The question is that Clause 102 stand part of the bill. As many of that opinion say aye.
Aye.
If the contrary no, I think the ayes have it. Schedule 14 has just been debated. The question is that Schedule 14 be the 14th schedule to the bill. As many of that opinion say aye.
Aye.
If the contrary no, the ayes have it. Schedule 15 has just been debated. The question is that Schedule 15 be the 15th schedule to the bill. As many of that opinion say aye.
Aye.
If the contrary no, the ayes have it. Clause 103 has also just been debated. The question is that Clause 103 stand part of the bill. As many of that opinion say aye.
Aye.
Of the contrary no, I think the ayes have it. We now come to the question that Clause 104 stand part of the bill. Minister.
Thank you, Ms Littlebuck. It is a pleasure to serve you in the chair this afternoon. Clause 104 seeks to build on existing polygraph testing powers by making an express provision to enable the Secretary of State to impose mandatory polygraph testing as a licence condition for the most serious offenders who commit historic offences connected to terrorism or who pose a risk of sexual offending. Now, polygraph tests are used to monitor compliance with licence conditions, and the information obtained from a test is used by probation practitioners to refine and strengthen risk management plans, thereby providing probation practitioners with additional risk-related information that they otherwise would not have known. Without this clause, these serious offenders would remain excluded from polygraph testing whilst on licence. Polygraph tests have been successfully used by the Probation Service in the management of sexual offenders since January 2014. Initially, this was a successful pilot and later a national programme. More recently, it was extended to terrorist offenders by the Counter-Terrorism and Sentencing Act 2021. Subsection 3 of this clause extends eligibility for polygraph testing to offenders who have been convicted of murder and are assessed as posing a risk of sexual offending on release. It also extends to those who are serving multiple sentences alongside a sentence for a sex offence to make sure that they can be polygraph tested for the duration of their licence. This is because there is a gap in the existing powers, which means that currently, for example, someone can be polygraph tested on licence when they have been convicted of rape, but if they have raped and murdered the victim, they are unlikely to be able to be polygraph tested because the sentence for rape is likely to have ended prior to their release on licence. Subsections 4 to 8 of this clause extend polygraph testing to a cohort of individuals who committed a non-terrorism offence, such as conspiracy to murder, that would have been considered terrorist-connected, but their offence was committed before the relevant legislation came into force, enabling the court to make a formal determination of there being a terrorist connection. We refer to this cohort as historic terrorism-connected offenders. Following this amendment, where it is determined by the Secretary of State that an offence was an act of terrorism, that an offence was an act of terrorism and it took place in the course of an act of terrorism or was committed for the purposes of terrorism, individuals will become eligible to have the polygraph condition applied to their licence, subject to meeting the relevant policy criteria. The polygraph testing licence condition is a vital tool for probation practitioners managing individuals who have been convicted of terrorism offences, and yet it cannot currently be applied to historic terrorism-connected offenders. This means polygraph is not available as a tool to manage the risk posed by this cohort, whereas it is available for an individual who commits the same offence today. This clause will therefore fill this gap in legislation and contribute to a consistent and effective risk management of historic terrorism-connected offenders and in the community. This clause seeks to close these small but significant operational gaps. Taken as a whole, Clause 104 will therefore ensure that polygraph testing can be used to strengthen the management of those who committed historic terrorism-related offences and those who pose a risk to sexual offending. And I commend Clause 104 to the committee.
Yeah.
Thank you. Clause 104 broadens the use of polygraph testing for offenders by amending the Offender Management Act 2007. It allows polygraph testing for individuals convicted of murder upon release if they pose a risk of committing a sexual offence and are 18 or older. It also applies to offenders who have served time for a relevant sexual offence, provided they are 18 or older at release. Additionally, the definition of relevant offence is expanded to include terrorism-related offences, including those committed for terrorist purposes. The provision functions as a preventative safeguard. Polygraph testing can act as a deterrent, encouraging compliance with licence conditions by reminding offenders that their conduct and disclosures will be monitored. This is especially significant where there are concerns about future harmful behaviour, even if the original offence did not relate to sexual offending. The clause provides tools to manage individuals involved in terrorism-related offences, helping authorities gather intelligence and make informed decisions on their supervision. It also promotes consistency in supervision, as polygraph conditions are already used for sexual and terrorist offenders, ensuring a balanced approach to risk management across high-risk groups. What safeguards ensure the Secretary of State's discretion in determining risk is transparent and fair? And given that polygraph evidence is not admissible in trials, why is it being increasingly used as a post-sentence supervision condition? Will there be an independent review of its effectiveness in reducing reoffending among these newly included categories.
Minister.
Thank you. I thank the Shadow Minister for his questions. Just on the basis of the Secretary of State's decision that he asked me. So if following a Secretary of State decision that for the purposes of extending polygraph testing an offence was an act of terrorism or was committed for the purpose of terrorism and a court does not reach the same decision, the Secretary of State will review their decision in light of the court's findings. This is an important backstop. Guidance will be produced in relation to this process of designation of terrorist connections by the Secretary of State and the court for the different management changes in the bill. And I would stress that polygraph testing is one of many tools available to the probation service when managing offenders in the community and when they are out on licence. This will not be the only tool available in that arsenal to ensure that the public are kept safe.
The question is that 104 stand part of the bill. As many of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. We now come to the question that clause 105 stand part of the bill. Minister.
Thank you, Chair. Honourable members, this clause will create a new duty on offenders serving a sentence in the community and who are supervised by probation or a youth offending team, requiring them to inform the responsible officer if they change their name, use a different name or change their contact information. I would personally like to thank my very good friend, the Honourable Member for Newport West and Islwyn, Ruth Jones MP, for her work in the last Parliament on this issue, and I am delighted to be bringing this forward today. This will improve the ability of probation and youth offending teams to monitor offenders in the community. It will ensure that the public are protected so that while the significant number of offenders are serving a sentence in the community, responsible officers have the information that they need to keep tabs on that individual, including if they change their name and their contact information. The provision in this clause are robust. While the name of or contact details change could be for any reason, any difference from what is kept on file must be reported by the offender. It captures not just formal legal changes of name by deed poll, but also, for example, the use of an online alias. While we have a separate youth justice system, it is of equal importance that services are able to maintain contact with children and have the right information about them to do their jobs. This policy, therefore, applies equally to offenders of all ages and will create consistency across offenders on licence and offenders serving sentences in the community overseen by probation services or youth offending teams. In terms of non-compliance, probation and youth offending teams will have discretion as to whether an offender is returned to court if they fail to comply with this requirement. It is right that the enforcement provisions for this clause are robust and reflect the seriousness of non-compliance, and it is right that probation officers and youth offending teams have the same powers to deal with non-compliance with this duty as they do in any other case of non-compliance with a sentence requirement. Madam Chair, I commend clause 105 to the committee.
Clause 105 requires certain offenders, including those under referral orders, youth rehabilitation orders, community orders and suspended sentence orders, to provide up-to-date contact information to relevant authorities. Offenders must notify their responsible officer or panel member of any changes in names, phone numbers or email addresses as soon as reasonably practicable, after the relevant order is made or after they begin using new contact details. For youth offenders under referral orders, the clause adds a new section to the sentencing code, mandating them to inform a youth offending team member of any aliases and current contact details as soon as reasonably practicable. Similar requirements apply to offenders under other orders, covering both future and existing orders. The overarching aim of Clause 105 is to close a monitoring gap by ensuring that responsible authorities are kept fully informed of how to reach the offender. This is particularly important for managing compliance with rehabilitative requirements, preventing individuals from circumventing supervision through undisclosed identities or means of communication. Can the Minister clarify what threshold is intended by the term reasonably practicable in this context? Given that this phrase is open to interpretation, will there be statutory guidance issued to ensure consistent application by youth offender panels and responsible officers?
Thank you. Thank the Shadow Minister for his questions. We will, of course, make sure that guidance is available to those for this new measure so that we provide individuals, the responsible officers, with all the tools available to protect the public safe, to ensure that they have all of the relevant and right information available for the management of offenders in community on licence.
The question is that clause 105 stand part of the bill. As many of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. We now come to the question that clause 106 stand part of the bill, with which it will be convenient to also consider clauses 107 to 109 stand part and new clauses 23 and 31. Minister.
Thank you, Mrs Lilbuck. And this part 13 of the bill pertains to matters relating to the police. And before I turn in detail to clauses 106 to 108, it may assist the committee if I first provide some context for these provisions. Following the shooting of Chris Carver and the subsequent trial and acquittal of Sergeant Martin Blake in October 2024, the Home Secretary made a series of commitments in response to the issues raised under the previous government's accountability review. The measures announced by the Home Secretary will rebuild confidence in police accountability systems for both the public and policing. As the Home Secretary said when making her announcement, the case happened against a backdrop of wider and long-standing concerns about accountability, standards and confidence in policing. The British model of policing relies on mutual bonds of trust between the public and the police. For our model of policing to work, it is essential that the police have the confidence of the communities they serve and that officers have the confidence that they need to do their vital and often extremely difficult job of keeping us all safe. Too often in recent times, both elements of that confidence have become frayed. Clauses 106 to 108 give effect to certain findings of the accountability review. Clause 106 will improve timeliness in the system by allowing the IOPC to make referrals to the Crown Prosecution Service prior to completing their final report. Clause 107 will amend the threshold for the Independent Office for Police Conduct, the IOPC, to make referrals to the Crown Prosecution Service. And Clause 108 places the IOPC victims' right to review scheme on a statutory footing, further improving the robustness of the IOPC's investigative process. So turning first to Clause 106, this will improve timeliness in the misconduct system. At present, there are a number of factors which cause delay in the misconduct system. One of these relates to the fact that in order for the IOPC to make a referral to the CPS, they are legally required to complete their final report concluding their investigation, and this causes delays in making referrals. The final report has to include misconduct findings and lessons learned for the IOPC. Such elements are not required for referrals to be made to the CPS, so the change we are making will enable the IOPC to make a referral prior to completing their final report, allowing for an improvement in pace in the accountability system. Next, currently the law states that the IOPC may refer a police officer to the CPS where there is an indication that a criminal offence may have been committed. This is a relatively low bar for making referrals to the CPS. Clause 107 changes this to bring it in line with the threshold that the police apply when making referrals of members of the public, which requires there to be a realistic prospect of conviction. It is right and fair that, as a result of this change, officers and members of the public will be referred to the CPS at the same threshold. The CPS will continue to make charging decisions at the same threshold, which is the full code test, and this change will improve overall fairness in the system. Finally, the IOPC's Victims' Right to Review currently allows for victims and their families to challenge the IOPC when they decide not to refer matters to the CPS. This right is currently available to victims and their families through guidance. Clause 108 places this right on the statute books to protect victims and demonstrate our clear commitment to victims' rights. Taken together, this is a balanced package of measures which help speed up IOPC investigations while strengthening the rights of those who may be aggrieved by the outcome of an investigation. Clause 109 amends the powers of the Secretary of State to make provisions on appeals to the Police Appeals Tribunal. It will enable Chief Constables to appeal the findings of outcomes of police misconduct proceedings, with a similar right for Police and Crime Commissioners to appeal where the officer subject to proceedings is a Chief Constable. It will also enable a right of appeal to be conferred on the Director General of the IOPC, where the IOPC has presented the case at the misconduct proceedings. This government is committed to restoring public trust and confidence in policing, something fundamental to our model of policing by consent, as I just said. But whilst the majority of our police officers act with bravery and integrity, where things go wrong, the public rightly expect that there is a system to robustly hold the police to account. In the context of recent high-profile cases which have damaged that vital trust and confidence, Chief Constables must be empowered to drive up standards. But whilst Chief Constables are themselves rightly held to account for standards in their forces, they are not afforded the same ability to challenge disciplinary decisions of officers in their force. As the officers in their force. Chief Constables' only route to challenge decisions which they consider to be unreasonable is through a judicial review. And this is a lengthier and more complex process than the existing Specialist Police Appeals Tribunal. Clause 109 will therefore allow the Secretary of State to make amendments to existing rules. Firstly, it will provide for a right of appeal for Chief Constables to challenge the findings or outcomes of misconduct proceedings in relation to officers within their force, and an equivalent right of appeal for police and crime commissions where the officer concerned is a Chief Constable. This is designed to ensure parity within the system, supporting the wider responsibilities of police and crime commissioners in respect of Chief Constables. And furthermore, it will provide an equivalent right of appeal for the Director General of the IOPC, but limited to those circumstances in which the IOPC has presented at the misconduct proceedings. And again, this supports public trust and confidence by ensuring vital independence in the system in the most serious and sensitive cases. Amendments to the secondary legislation will be developed in consultation with the sector, including the Police Advisory Board for England and Wales. I also note that new clauses 23 and 31 are in this grouping, and I will respond to those once we've heard from the Shadow Minister.
Thank you. On 5th of September 2022, an armed police officer shot and killed Chris Cabba during a vehicle stop in South London. The police referred the case to the Independent Office for Police Conduct, as required when someone dies or is seriously injured in police custody or contact. The IOPC investigated and referred the case to the Crown Prosecution Service, which authorised a murder charge in September 2023. Concerns over accountability systems led the Home Office to launch a review in September 2023. In March 24, the officer was identified, and the Home Secretary announced 3 immediate changes to improve accountability: raising the threshold for CPS referrals, relaxing restrictions on criminal proceedings, and formalising victims' rights under the IOPC's Victim Right to Review policy. Clauses 106 to 108 implement these policy proposals, which had previously been tabled as amendments to the Criminal Justice Bill. Clause 106 introduces significant procedural reform to allow certain criminal investigations into police misconduct to be expedited. It's clear that this clause will help to significantly speed up accountability, especially in cases involving clear and serious misconduct by police officers. By allowing criminal proceedings to be brought sooner, it reduces the delay in holding individuals accountable for their actions, ensuring justice is not unduly postponed. In situations where there is clear evidence of misconduct, this allows for quicker action. This quickened response can help reassure the public that where there are serious allegations, the authority are acting swiftly and decisively. It demonstrates that law enforcement and oversight bodies are committed to transparency and integrity. What safeguards are in place to prevent inappropriate or premature referrals to the DPP under this accelerated procedure, and how will the IOPC or appropriate authority be held accountable for determinations made? Currently, chief officers have no right of appeal against panel decisions and may only challenge outcomes via judicial review. In October 2022, the government launched a review of the dismissal process, with findings published in September 23. Recommendations included a presumption of dismissal for gross conduct, automatic gross misconduct designation for certain convictions, streamlined performance and vetting-based dismissal processes, and a new appeal right for chief officers. Met Commissioner Sir Mark Rowley welcomed these reforms, citing the need for greater control to uphold standards. However, the Police Federation criticised the changes, warning they could undermine fair hearings and lead to excessive influence by chief officers, risking biased outcomes. Under the proposals set out in Clause 109, Chief Constables will be granted the right to appeal both the findings of misconduct hearings, such as whether misconduct or gross misconduct is proven, and also appeal the sanctions imposed, for example, a written warning. Given that the Police Federation has raised concerns about the potential for biased outcomes due to chief officers having a right of appeal, what safeguards are in place to maintain the independence and objectivity of misconduct hearings, especially in cases where the chief officer is personally involved? Opposition New Clause 23 seeks to amend the Police Reform Act 2002 so that a police officer's previous conduct must be considered when deciding whether to investigate a new complaint against them. It allows for some discretion in handling complaints that may be trivial, repetitive, or otherwise not requiring formal investigation. This amendment would prevent officers with a concerning history of conduct from escaping scrutiny simply because each complaint is viewed in isolation. It introduces a cumulative view of conduct which can help identify patterns of behaviour that might otherwise go unnoticed. This is especially relevant in light of high-profile cases where officers remained in service despite multiple complaints. This clause is a preventative mechanism, ensuring that repeat allegations aren't dismissed as isolated incidents. The new clause seeks to close a potential loophole in the police complaints process by requiring that past misconduct be considered when assessing new allegations. It reflects a growing demand for greater transparency, accountability and rigour in dealing with officer behaviour, especially where there is a history of concern. New Clause 31 seeks to strengthen the legal framework around police vetting by introducing a mechanism for the automatic dismissal of officers who fail vetting unless exceptional circumstances apply. The clause proposes that where an officer fails vetting and is not reasonable to expect that they will be deployable to full duties within a reasonable time frame, they may be dismissed. This aims to ensure that individuals who no longer meet the basic standards of integrity and trustworthiness required for policing cannot remain in the force indefinitely in limited or administrative roles. Importantly, the clause includes a safeguard to prevent unfair or disproportionate outcomes. If a chief officer believes that, despite the vetting failure, the officer is still capable of performing a substantial majority of duties appropriate for their rank, and that dismissal would undermine the operational effectiveness of the force, they can decide not to proceed with the dismissal. This ensures the decision remains proportionate and sensitive to operational realities. This clause also builds on recommendations made in the Government's 2023 review of police officer dismissals, which advocated for a clarified and consistent route for removing officers who fail vetting. By embedding this power in legislation, the clause would give chief officers clearer authority to act in the interest of police professionalism and public trust.
Well, first of all, I welcome what the Shadow Minister said, and clearly there's been no changes from the clauses that were introduced in the Criminal Justice Bill and that are now within the Crime and Policing Bill. So I think we're on the same page in terms of these being the right and appropriate measures to take forward. And I'm really grateful that the Honourable Member for Stockton West has set out in detail the case for introducing the new clauses and seeking to ensure that they work in policing and are fit for purpose, and everyone who's in policing is fit to be a police officer. And I'd like to first reassure the committee that this government takes police integrity very seriously, and it's essential, as I said in my remarks, that we have public confidence in policing, we have the highest standards upheld and maintained. And particularly on the new clauses that the Honourable Gentleman has brought forward, I think it's clear we all agree that individuals who fall below the standards that the public expect should not be police officers. So just dealing specifically with new clause 23, which seeks to ensure that previous complaints or convictions are considered a factor in determining when a complaint against an officer should be handed formally under Schedule 3 to the Police Reform Act 2002. And while I recognise the Honourable Member's desire to strengthen the legislation to this effect, in reality, these elements are already established practice. Under existing statutory guidance issued by the IOPC, previous complaints against an officer should be taken into account when considering whether to handle a complaint under Schedule 3. All those working in policing must have regard to this statutory guidance, and compelling forces to record complaints under Schedule 3, whether a historical complaint exists on an officer's record, would limit their ability to handle those complaints in the most proportionate manner and in the interests of the complainant. And similarly, in relation to historic convictions, this information is available to forces on the Police National Computer and is relevant in determining the most appropriate way to handle a complaint. This government has committed to ensuring vetting rules are strengthened with regard to historic convictions, and we intend to put vetting standards into law, mandatory vetting standards into law this year, so that those who have committed certain offences cannot hold vetting and serve as police officers. So turning to new clause 31, this would amend the Police Act 1996 to ensure that a code of practice may provide that a police officer who fails their vetting will be dismissed without notice. Now, it may be of help to the committee to understand that this government has acted rapidly to develop new regulations in this area, and that those regulations will enable forces to dismiss officers who cannot maintain vetting clearance. These have taken into account the relevant legal proceedings, such as the Di Maria Judicial Review, which considered the adequacy of the Metropolitan Police Service processes to remove those officers without vetting clearance. So the police vetting regulations, which were laid just last week on the 23rd of April, introduced a duty for police officers to hold and maintain vetting clearance, and provides a bespoke regulatory mechanism by which they can be dismissed should they fail to do so. The government also strongly believes that there should be no circumstances in which an officer who is unable to hold vetting clearance should remain in policing. And so I cannot support the qualification in new clause 31, which suggests an officer may be capable of deployment to other duties despite failing to maintain their vetting clearance. And I hope that, having had the opportunity to consider the existing framework around complaints and the new regulations which I just referred to, and the ongoing work to strengthen the rules around vetting, that the Honourable Member would be content not to move his new clauses later in our proceedings. And I also just wanted to respond to the particular point about the IOPC and how they will keep an eye on the changes that are being introduced. And I think it's quite clear that there will be scrutiny of what happens under these new changes, and if there are emerging patterns of cases where, for instance, the CPS declined to charge an officer despite the IOPC referral, then I would expect the IOPC to consider whether there are lessons to be learned and a further review to be undertaken.
The question is that clause 106 stand part of the bill. As many of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. Clauses 107 to 109 have just been debated. With the leave of the committee, I'll put a single question on those clauses. The question is that clauses 107 to 109 stand part of the bill. Many of that opinion say aye.
Aye.
Of the contrary, no. The ayes have it. We now come to Government Amendment 53 to clause 110, with which it will be convenient to consider Government Amendments 54 and 55 to clause 110. Clauses 110 and 111 stand apart, and Government New Clause 61. Call the Minister to move Government Amendment 53. Minister.
Thank you, Ms Slowbrook. And Part 14 of the bill concerns counter-terrorism and national security. Protecting the public is the first duty of any government, which is why national security is a key pillar of the government's plan for change. The UK has one of the strongest counter-terrorism frameworks in the world, but we cannot stand by whilst threats evolve. As the Home Secretary has set out in her statements to the House, the Security Service, counter-terrorism policing and the independent review of terrorism legislation have all consistently raised concerns related to the increasing number of young people being investigated for terrorism offences. Whilst there must always be the potential to pursue prosecutions for the most serious cases, it is important that we ensure there are alternative risk management measures that don't automatically result in a terrorism conviction for a young person, which can have a hugely destructive impact on their life prospects. So we have listened to operational partners about the need for alternative and earlier interventions, and we are taking the opportunity to build on a recommendation made by the Independent Reviewer of Terrorism Legislation, Jonathan Hall KC. Chapter 1 of Part 14 therefore introduces new Youth Diversion Orders, or YDOs. YDOs will be a new civil order designed to better manage terrorist risk from young people while reducing the need for their further involvement in the criminal justice system. They demonstrate this government's commitment to ensuring operational partners have the tools they need to reduce terrorism risk and support rehabilitation. Clause 110 introduces a new power for the police to apply to a youth or magistrates court for a YDO. To impose a YDO, the court will need to be satisfied on the balance of probabilities that the respondent has either committed a terrorism offence, committed a non-terrorism offence with a terrorism connection, or engaged in conduct likely to facilitate the commission of a terrorism offence. The court will also need to consider that it is necessary and proportionate to make the order to protect the public from a risk of terrorism or serious harm, as defined in Clause 111. This ensures that these new orders are only imposed where there is a serious risk to the public. The technical government amendments 53, 54 and 55 adjust the definition of offence with a terrorist connection so as to avoid the need to refer to legislation relating to sentencing. Sentencing will not take place in YDO applications, but the judge considering a YDO application will be able to consider whether the individual has committed an offence with a terrorist connection, in the same way as a judge would consider this on sentencing. Finally, new clause 61 requires individuals to provide their personal details to the police, where a YDO includes notification requirements. The relevant details are the respondent's name, including any aliases, and their home address. This requirement will not be automatic or mandatory for every YDO, but will need to be agreed by the court on a case-by-case basis. The notification requirement will also include a requirement to provide information about the individual's school or other educational establishment if relevant. This information would be helpful, for example, in a scenario where someone moves school and there was otherwise no trigger for the local authority to inform the police of the move. This new clause is supported by the Independent Reviewer of Terrorism Legislation, and operational partners have confirmed as well that it is necessary to support the effective day-to-day management of YDOs. And I commend the Government's amendments to the committee, and I beg to move.
Government Amendment 53 proposed to clause 110 as on the amendment paper. The question is that the amendment be made. Mark Vickers.
The new youth diversion orders are designed as a counter-terrorism risk management tool for individuals under the age of 21. The purpose of the YDO is to divert young people from engaging in terrorist activities and to allow police to intervene at an earlier stage. Clause 110 grants the police the authority to apply to the courts for a YDO. Clause 110 clarifies that a youth diversion order can be applied for by a chief officer of police when the respondent meets certain criteria based on age and involvement in terrorist-related offences. In England, Wales, Northern Ireland, the respondent must be ages between the ages of 10 and 21. In Scotland, the age range is 12 and 21. The aim of the order is diversion rather than punishment. The youth diversion order is intended to help prevent further involvement in terrorism or related activities. The order may include rehabilitation, counselling or other interventions designed to steer the individual away from terrorism-related conduct. Clause 111 defines serious harm in the context of youth diversion orders. The new Clause 61 introduces notification requirements for a youth diversion order, where the respondent must notify the police within 3 days of being served with the order. This notification includes providing personal details such as the respondent's name, any additional names, home address, the name and address of any education establishment the respondent normally attends. This notification is intended to help ensure the youth's compliance with the order, as well as assist in tracking their progress or potential risks of non-compliance. The approach strengthens the monitoring aspect of youth diversion orders by tying in an educational component. It ensures that authorities have up-to-date information regarding the young person's school involvement, which can be a crucial element in their rehabilitation. Can I ask the Minister, how will the Government ensure that the notification requirements, particularly concerning educational details, do not inadvertently stigmatise or disrupt the young person's educational experience, especially in cases where the individual may already be vulnerable or at risk of exclusion from school?
Minister.
I'm grateful for the comments of the Shadow Minister. Am I right in thinking that the Shadow Minister believes that information will be made available to the public? Is that the issue around information around schools and about stigmatising?
But it may be with those educational settings.
Sorry.
Yeah, sorry.
I wasn't quite clear with the point.
Yeah, with those educational settings, if you're giving them the details and the contact, will that be something that could then be reflected in that education?
Well, I don't wish to try your patience, Mrs. Lowe, but my understanding is that this is not going to be public information that would be shared, that this would be information obviously either within the youth court or the magistrates court, but I'm looking to my officials who are nodding at me, so this is not going to be information that would be in the public domain. So I'm hoping that that would deal with the point around any stigmatisation of a young person who was subject to a YDO. And on that basis, I beg to move.
Government Amendment 53 proposed to clause 110 as on the amendment paper. The question is the amendment be made. As many of that opinion say aye.
Aye.
To the contrary, no. I think the ayes have it. Government Amendments 54 and 55 to clause 110 have already been debated. With leave of the committee, I will put a single question on those amendments. I call the Minister to move the amendments.
Formally.
The question is that Government Amendments 54 and 55 to clause 110 be made. As many of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. Clause 110 has just been debated. The question is that clause 110 as amended stand part of the bill. As many of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. Clause 111 has also just been debated. The question is that clause 111 stand part of the bill. As many of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. We now come to Government Amendment 56 to clause 112, with which it will be convenient to consider Government Amendments 57 to 59, Amendment 40, and Government Amendment 60 to clause 1112, clause 1112 stand part, and Government new clauses 62 and 63, and Government Amendment 79. I call the Minister to move Government Amendment 56. Minister.
Thank you, Mrs. Lilbrook. Clause 112 sets out a non-exhaustive list of prohibitions or requirements that may be included in a YDO and the safeguards that the police and courts must consider. The police must have the ability to mitigate risk to the public from young people being drawn into terrorism, and this is a growing problem, as we all appreciate. The YDO will enable the police to impose necessary restrictions on an individual subject to a court order. These may include limits on accessing certain websites or apps, or restrictions on engaging with specific individuals or groups. For example, this could include engagement with other children who have been assessed to be vulnerable to radicalisation. A YDO may also include positive requirements which the respondent must comply with. These may be rehabilitative in nature, including, for example, mandatory attendance at intervention sessions which seek to support the respondent away from extremist ideologies. Whilst it is critical that the police are able to impose necessary risk management and rehabilitative measures, the legislation ensures that there are safeguards to limit the extent of such measures. First, each measure must be necessary and proportionate for the purpose of mitigating a risk of terrorism or serious harm. Second, any measure included as part of a YDO must not unnecessarily interfere with the respondent's educational or work commitments or religious beliefs. And third, they may not exceed a total duration of 2 years. This is to ensure that YDOs have enough time to have a positive impact on a young person's life, whilst remaining proportionate to the scale of the risk to the public they pose from being drawn into terrorism. The Government's amendments to Clause 112 provide further examples of the measures that may be imposed through a YDO. This increases transparency and provides a clear statutory basis for the most intrusive measures that will be available under the YDO. The expanded list of prohibitions and requirements in Clause 112, as it would be amended, represents the measures that we expect the police will most commonly apply to the court to include in a YDO. Specifically, Amendment 57 allows for potential restrictions on entering a specific area, including travel restrictions within or outside the UK. Amendment 58 outlines potential requirements for the respondent to answer questions, provide information or produce documents. Amendment 59 provides that if included in a YDO, the individual may be required to comply with notification requirements as detailed in new Clause 61 and may be subject to restrictions on the possession of weapons and explosives. Amendments 56 and 60 are consequential on these other amendments. Turning next to new clauses 62 and 63 and Government Amendment 79, these enable a YDO to include an electronic monitoring requirement. This will enable effective monitoring of and compliance with measures such as curfew requirements and exclusion measures. Operational partners have been explicit. Having this capacity and capability will maximise the utility of the YDO and the effectiveness of the measures contained within an order. Finally, turning to Amendment 40, tabled by the Shadow Minister, this seeks to give the police the ability to apply for a YDO in cases of a young person exhibiting extremist views and would prevent an order from expiring unless there was an independent expert assessment that the individual no longer posed either a terrorist risk or held extremist views. Now, YDOs are designed for terrorism-related cases only. The YDO is a tool to be used only when young people pose a public safety risk. There are no plans to use YDOs for cases that do not meet terrorism thresholds, as this would interfere with the rights of young people. This government takes extremism seriously, very seriously, and we are committed to ensuring that we have the required tools and powers needed to address this issue. Efforts to counter extremism span a broad range of government and law enforcement activity, and we must persist in our efforts to challenge extremist narratives, disrupt the activity of radicalising groups, and directly tackle the cause of radicalisation. The Home Office leads the work on countering extremism, and the Ministry of Housing, Communities and Local Government will lead on the work on strengthening community cohesion with local councils. It is vital that the two programmes on cohesion and extremism work in parallel. In relation to the length of a YDO, subsection 4 of clause 116, which we will debate in a later group, this permits the police to apply for an extension of the order. Each extension would be for a maximum of 6 months and may be applied for twice, so the maximum duration of an order may not surpass 2 years in total. And I want to reassure the Honourable Member that counter-terrorism policing will assess the individual's risk on a regular basis whilst the order is in force. Whilst it will be a decision made on a case-by-case basis, they may decide to apply to the court to extend an order. Where the police assess that the risk posed by the respondent remains despite the order having been in place, they may consider, in consultation with the relevant prosecutorial authorities, whether the relevant tests for prosecution for terrorist offending are met. Should the risk the individual poses remain for longer than 24 months, there are other tools which may be considered. And for the reasons I have just set out, I hope the Shadow Minister will agree to withdraw Amendment 40. Given the clear operational need for the Government's amendments, I commend them to the committee.
Opposition Amendment 40 primarily focuses on the duration, assessment and possible extension of the YDOs, ensuring that these orders are subject to review and that further intervention is applied when necessary. Under the amendment, however, the order must specify a period specified up to 12 months within which the young person is monitored and guided through the diversion programme. This ensures that there is a clear time limit with a defined endpoint for the intervention. Additionally, before the order concludes, an assessment must be carried out to evaluate whether the individual continues to hold extremist views or poses a terrorism threat. This adds an important safeguard to the process, ensuring that young people who may still be a risk are identified before the order ends. A critical aspect of this amendment is the requirement for qualified experts to carry out the assessment. The evaluation of whether the individual continues to hold extremist views or presents a terrorism risk must be conducted by an expert in extremism and counter-terrorism. This ensures that the assessment is informed by a high level of expertise and understanding of the complexities of radicalisation. Furthermore, assessments made by the youth offending team must be reviewed by an external expert who has no pre-existing relationship with the respondent. This independent review guarantees objectivity and minimises any potential bias in the evaluation process. If the individual is assessed as still holding extremist views or continuing to pose a terrorism risk, the youth offending team or a chief officer of police has the power to apply to the court for an extension of the youth diversion order. This extension can be granted for an additional 12 months, allowing continued intervention and monitoring of the individual. Importantly, this extension ensures that the order remains in place for as long as the individual is considered a risk to public safety. Finally, the amendment specifies that all provisions, prohibitions and requirements set by the YDO will remain in effect until the individual has been assessed as holding no extremist views or posing no terrorism threat. This ensures that the protective measures stipulated in the order are maintained throughout the duration of the individual's involvement in the diversion programme, offering ongoing protection to the public while allowing for continued monitoring of the individual's risk level. This amendment ensures that the diversion process is both effective and responsive to the changing nature of extremist behaviour. It also ensures that any decision to conclude or extend the order is based on robust and independent expert evaluations, thus improving the overall effectiveness of the youth intervention measures in countering extremism and terrorism. Clause 112 outlines the content and conditions of a youth diversion order, providing the framework for how the order can be structured and what it can include. How will the government ensure that YDOs do not interfere with religious or cultural practices of respondents as per the clause, especially when it comes to limitations on association or communication?
My sincere apologies to the committee. Before I called the Shadow Minister to speak, I should have said Government Amendment 56 proposed to clause 112 as on the amendment paper, and the question was that the amendment be made. I now call the Minister.
Thank you very much, Mrs Lillbrook. And I think on that particular question that the Shadow Minister just posed, I said in my earlier remarks that there would not be restrictions that interfered with educational and work commitments and also religious observance as well. So I think that probably deals with the question that the Shadow Minister raised with me. And on that basis, I beg to move.
Government Amendment 56 proposed to clause 112 as on the amendment paper. The question is the amendment be made. As many of that opinion say aye.
Aye.
If the contrary no, I think the ayes have it. Government Amendments 57 to 59 to 57 and 59 to clause 112 have already been debated. With leave of the committee, I will put a single question on those amendments. Call the Minister to move the amendments. The question is that Government Amendments 57 to 59 to clause 112 be made. As many of that opinion say aye.
Aye.
If the contrary no, I think the ayes have it. Amendment 40 proposed to clause 112 as on the amendment paper. The question is that the amendment be made. Would the Shadow Minister like to push to a vote?
Sorry, yeah.
Okay. So as many of that opinion say aye.
Aye.
Of the contrary, no.
No. Aye.
Division. Okay, Mr. Alex Burrows-Curtis.
No.
Harriet Cross.
Aye.
Alex Davis-Jones.
No.
Jane Diana Johnson.
No.
Louise Jones.
No.
No. Keir Mather.
No.
Joe Platt?
No.
Jack Rankin?
Aye.
Anna Sabine?
Abstain.
David Taylor?
No.
Luke Taylor? And Matt Vickers?
Aye.
The ayes were 3, the noes were 7. So the noes have it. Unlock. We now come to Government Amendment 60 to Clause 112, which has already been debated. Call the Minister to move the amendment formally. The question is that Government Amendment 60 to Clause 112 be made. As many of that opinion say aye.
Aye.
If the contrary no, I think the ayes have it. Clause 112 has also just been debated. The question is that Clause 112, as amended, stand part of the bill. As many of that opinion say aye.
Aye.
Of the contrary no, I think the ayes have it. We now come to Government Amendment 61 to Clause 113, with which it will be convenient to consider Government Amendments 62, 64 and 63. Clause 113 stand part, Government Amendments 65 and 66. Clause 114 stand part, Government Amendment 67 and Clause 115 stand part. I call the Minister to move Government Amendment 61. Minister.
Thank you. Clauses 113, 114 and 115 set out duties on the police to consult with relevant authorities, provide for applications to be made without notice in urgent circumstances, and provide for interim YDOs to be made. The committee will recognise the importance of ensuring the police take wider factors into consideration before applying for a YDO, for example, a person's age, mental health, safeguarding and educational needs. Clause 113 therefore introduces a duty to consult before applying for an order or applying for a variation or discharge of an order. In England and Wales and Northern Ireland, the police will be required to consult with youth offending teams and the Youth Justice Agency, respectively, for applications involving individuals under the age of 18. In Scotland, the police will be required to consult with the Lord Advocate for all applications. This is necessary to give effect to different positions in Scotland, a different position in Scotland, where consultation is appropriate with the Lord Advocate for all YDOs, including for 18 to 21-year-olds, and also for without notice YDO applications. This reflects the Lord Advocate's specific functions in relation to their role as head of the system for the investigation and prosecution of crime, which includes a specific working relationship with Police Scotland. Government Amendments 62 and 65 also add an additional requirement in respect of Scotland, which is that the police consult with the local authority before making an application for a YDO, irrespective of the age of the respondent, and also removes the requirement for consultation with the Scottish Children's Reporter Administration for YDOs for under 18s. These amendments are again necessary to give effect to the different position in Scotland where there is no equivalent to youth offending teams. Government Amendments 63, 64 and 66 are consequential on these amendments, whilst Government Amendment 61 ensures consistency of drafting between the subsections of clauses 113 as amended. Now, consultation will be an important part of the YDO application process, ensuring that the police have thoroughly considered the necessity and proportionality of a YDO, and taken into account the expertise of those who work closely with young people in the community. This statutory duty does not prevent the police from engaging with other authorities, such as the CPS or the Public Prosecution Service in Northern Ireland, wider social services, or the respondent's school or college where appropriate. Whilst it is likely to be rare in practice, there may be circumstances where an urgent YDO application is required, and where providing notice to the respondent may increase risk. Therefore, Clause 114 provides a route for police to apply for a YDO without notice to the respondent. without notice to the respondent. The requirement to consult in this case does not apply, though the police will still be required to consult relevant authorities before the full court hearing for a YDO. Where an application is given without notice, the court will be able to consider whether to impose an interim order. This is in line with the approach taken with other preventative orders, such as knife crime prevention orders. Due to the temporary nature of an interim order, Clause 115 ensures that the only positive requirements that can be included in such an order are requirements to provide information and to comply with notification requirements. For example, the legislation does not allow the police to impose a requirement to attend intervention sessions similar to prevent in an interim order, but the police will be able to impose risk management measures where necessary and proportionate and subject to the court's permission. Finally, Amendment 67 clarifies the measures that can and cannot be imposed in an interim YDO. So I commend these amendments to the committee and I beg to move.
Government Amendment 61 proposed to clause 113 as on the amendment paper. The question is that the amendment be made. Mark Vickers.
Clause 113 outlines the duty to consult before making an application for a youth diversion order or the variation or discharge of such an order, particularly when the individual involved is under the age of 18. The provision ensures that key stakeholders are involved in the decision-making process to ensure the best interests of the young person are taken into account, while also ensuring that the relevant agencies are informed and consulted before any formal application is made. I'd like to ask the Minister how the Government plans to ensure that the agencies consulted, particularly the youth offending teams, have the necessary expertise and resources to adequately assess the case before the application for a YDO is made. Clause 114 outlines the process for making an application for a youth diversion order without notice to the respondent. This provision is significant because it allows for situations where immediate intervention is necessary, where the respondent is not notified before the application is made. How does the Government ensure that respondents' rights are protected in cases where the application is made without notice? What measures are in place to prevent potential misuse of this provision? Clause 115 outlines the provision for interim youth diversion orders during the adjournment of a hearing for a full youth diversion order. This provision ensures that even while a decision on the full application is pending, the court can take immediate temporary action to manage the respondent's risks, particularly in cases involving potential extremism or terrorism. On the whole, Clause 115 allows the courts to impose interim measures that temporarily manage a respondent's behaviour, safeguarding public safety while the full process is ongoing.
Minister.
Thank you, Mrs Lilbrook. And the Shadow Minister particularly raised the issue around the consultation with youth offending teams and the equivalent in the devolved administrations. It's quite clear, my understanding is we're not talking about large numbers of individuals who will be subject to these provisions. And clearly, the reason why we're saying that youth offending teams have to be consulted is because they do have the expertise and the knowledge of working with young people, and it's probably likely that these individuals that they're going to be consulted on will already be known to them. So I think it's a good form of a positive measure to make that consultation with youth offending teams and recognise the skills and the safeguards that they will also bring, because they will have probably that knowledge of the individual. And as I spoke about earlier, perhaps issues around their background or safeguarding issues that need to be considered. So I think that that's really important. And I think as to the point around interim youth YDOs, they may be required if there is an immediate risk that has to be managed, and I think that that's why there needs to be provision made for them. But of course they're interim, and there will then be a full hearing taking place, and they would only be used in urgent circumstances, and of course the court has to agree to this. So while an application can be made, if the court does not recognise that there is that urgency and the emergency that is being put before the court, then they won't be granted. And I also think that the independent reviewer of terrorism legislation has also agreed that there needs to be these interim powers, these measures that can be brought forward for YDOs to be effective. So I hope on the basis of those answers the Shadow Minister is satisfied that this clause should form part of the bill, or these clauses.
Government Amendment 61 proposed to clause 113 as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye.
Aye.
To the contrary, no. I think the ayes have it. Government Amendments 62, 64 and 63 to clause 113 have already been debated. With the leave of the committee, I'll put a single question on those amendments. Call the Minister to move the amendments.
Formally.
The question is that Government Amendments 62, 64 and 63 to clause 113 be made. As many of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. Clause 113 has also just been debated. The question is that clause 113 as amended stand part of the bill. As many of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. Government Amendments 65 and 66 to clause 114 have already been debated. Again, with leave of the committee, I will put a single question on those amendments. Call the Minister to move the amendments. Question is that Government Amendments 65 and 66 to clause 114 be made. As many of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. Clause 114 has also just been debated. The question is that clause 114 as amended stand part of the bill. As many of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. We now come to Government Amendment 67 to clause 115, which has already been debated. I call the Minister to move the amendment formally. The question is that Government Amendment 67 to clause 115 be made. As many of that opinion say aye.
Aye.
The contrary, no. I think the ayes have it. Clause 115 has also just been debated. The question is that clause 115 as amended stand part of the bill. As many of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. We now come to Government Amendment 68 to clause 116, with which it will be convenient to consider clause 116 stand part, Government Amendments 69 to 71 and clause 117 stand part. I call the Minister to move Amendment 68. Minister.
Thank you. Clause 116 ensures that the police or the subject of the YDO can apply to the relevant court to vary the order once it is in place. For example, to add or remove measures or to change the duration of existing measures. The clause also allows the police or the subject of a YDO to apply to end the order before it is due to expire, allowing the police to withdraw the order if it is no longer considered necessary. Clause 117 sets out the route for the police or a respondent to appeal against a court decision to impose a YDO, an interim YDO, or any change made under Clause 116. Appeals will be made to the Crown Court in England, Wales and Northern Ireland and the Sheriff Appeal Court in Scotland. The court may then make changes on the basis of that appeal as required. Government Amendments 68 and 71 make changes to clarify and streamline the appeals process for YDOs, as do Government's Amendments 69 and 70, which provide that a second appeal in relation to a YDO may be made to the Court of Appeal in England and Wales. The committee will recognise the importance of these clauses in ensuring that there is a process for varying or revoking the order, as well as for both the police and the YDO subjects to have a prescribed and proportionate route for appeals. I beg to move.
Government Amendment 68 proposed to clause 116 as on the amendment paper. The question is that the amendment be made. Minister, anything further to add?
No, nothing further to add.
Government Amendment 68 proposed to clause 116 as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye.
Aye.
Contrary, no. I think the ayes have it. Clause 116 has also just been debated. The question is that clause 116 as amended stand part of the bill. As many of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. Government amendments 69 to 71 to clause 117 have already been debated. With leave of the committee, I will put a single question on those amendments. Call the Minister to move the amendments. The question is that government amendments 69 to 71 to clause 117 be made. As many of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. Clause 117 has also just been debated. The question is that clause 117 as amended stand part of the bill. As many of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. We now come to Government Amendment 72 to clause 118, with which it will be convenient to consider Government Amendments 73 to 75. Clause 118 stand part. Government Amendment 76. Clauses 119 and 120 stand part. Government Amendments 77 and 78. Clause 121 stand part. Government new clauses 64 and 65 and new clause 42. I call the Minister to move Government Amendment 72.
Ms Lulbuck, I wondered whether it might be helpful to the committee if I responded after the Shadow Minister has spoken to his amendment that he's put down, the new clause 42. If that would be convenient.
Yep.
So Government Amendment 72 proposed to clause 118 as on the amendment paper. The question is that the amendment be made. Matt Vickers.
Clause 118 and 119 outline the offence of breaching a youth diversion order and subsequent processes for issuing and revising guidance on the exercise of functions related to youth diversion orders. Clause 118, subsection 4 ensures that if a person is convicted of breaching a youth diversion order, the court can issue a conditional discharge, requiring a substantive penalty instead. This provision prevents a lenient approach that might fail to deter non-compliance. The clause also establishes varying penalties based on age, with different consequences for individuals under and over 18. I'd like to ask the Minister how these penalties balance deterrence with the goal of rehabilitating young offenders, particularly those under 18. Additionally, Clause 119 grants the Secretary of State the authority to issue guidance for local police forces. I'm also curious as to how the Minister plans to ensure that this guidance brings consistency in the application of YDOs across different regions. Further clauses outline wider procedures and applications of YDOs. New Clause 42 mandates that the Secretary of State publish a report within 3 months of the passing of the Act, detailing the organisations responsible for implementing and enforcing youth diversion orders. The report must cover the organisations involved, the counter-terrorism and de-radicalisation training they possess, and any additional resources required to effectively manage the YDO provisions. Within 1 month of the report's publication, the Secretary of State must present a plan to address training, financing and guidance to meet the required standards. Additionally, the Secretary of State must commission an independent assessment by the Independent Reviewer of Terrorism legislation to evaluate whether the proposed levels of funding, training and expertise are adequate, with this assessment being laid before Parliament alongside the plan. This clause ensures the effective implementation of youth diversion orders with the necessary expertise. The requirement for report and plan ensures organisations are prepared to handle counter-terrorism and de-radicalisation issues. It sets clear expectations for training and funding, holding the government accountable for providing sufficient resources. The independent assessment by the Independent Reviewer of Terrorism legislation adds scrutiny, ensuring the government's plans meet the required standards. Overall, the clause demonstrates a proactive and transparent approach, fostering confidence in the system's ability to address terrorism and extremism. As such, I'd like to ask the Minister what steps the government is currently taking to ensure that the organisations involved in implementing YDOs have the necessary counter-terrorism and de-radicalisation training and expertise. Is the government confident that these organisations are sufficiently prepared without the need for an independent assessment? Additionally, given the complexity of implementing YDOs, does the Minister agree that the additional resources might be required to ensure these orders are effectively enforced? If not, what plans are in place to guarantee that the organisations responsible are adequately resourced.
Thank you, Mrs Lawbuck. Clauses 118 to 121 will support with the implementation of YDOs. And whilst the aim of a YDO is to divert a young person away from terrorist offending, it is critical that there is an effective deterrent against breaching the order, and that where a young person breaches the order, the police can take action. Clause 118 ensures that there is a separate criminal offence available for breaching a YDO without a reasonable excuse. In practice, we propose that statutory guidance will be set out, that the police will be expected to consult the youth offending teams where there is a suspected breach, and the police may consider alternatives to prosecution for less serious breaches, such as varying the measures in the order or issuing a formal warning to the individual. Therefore, prosecution for this offence will be a last resort. Now, Government Amendment 72 makes it an offence for a person to knowingly provide false information, produce a false document or notify false information in purported compliance with notification requirements imposed under a YDO. Government Amendments 73 and 74 make the offences under Clause 18 triable either way, irrespective of the age of the defendant, with a maximum penalty of 2 years imprisonment. These amendments ensure that there is a consistent maximum penalty for any breach of a YDO, regardless of how old the young person is, and more accurately reflects the potential severity of breaching a YDO. For example, a serious breach may involve a breach of a weapons measure, such as making plans to purchase knives or encouraging or assisting others to do so. We would expect a prosecution for this offence to be the last resort. Detail on other options to be considered beforehand will be included in the statutory guidance. This change is supported by operational partners and the independent reviewer of terrorism legislation. Government Amendment 75 enables a copy of a YDO to be admissible as evidence in criminal proceedings for breach of the order. Clause 119 introduces a new power for the Secretary of State to issue guidance to the police in relation to YDOs. In issuing this guidance, we recognise the importance of proper consultation with relevant authorities, including the police, the prosecution service in England and Wales and Northern Ireland, and the Lord Advocate in Scotland. That is why Clause 119 requires mandatory consultation with certain parties and permits the Secretary of State to consult with other stakeholders where appropriate. Government Amendment 76 expands the list of consultees to include youth justice agencies. Now, Clause 120 ensures that rules of court can provide for anonymity for individuals going through civil proceedings for a YDO. This is important to ensure reporting restrictions apply, and it is in line with the general policy aims of ensuring young people do not feel stigmatised, something I know the Shadow Minister was raising in the previous debate, through engagement with the justice system. Finally, Clause 121 makes procedural provision in respect of applications for a YDO. Government Amendment 77 to this clause disapplies the time limit that would otherwise prevent an application for a YDO being made in relation to matters arising more than 6 months prior to the making of the application. Lastly, Amendment 78 enables proceedings in Scotland for or in relation to a YDO to be heard by a summary sheriff. Moving on to the government's new clauses in this group, in order to effectively safeguard the data gathered under electronic monitoring requirements, new clause 64 requires the Secretary of State to issue a code of practice for the processing of such data. The processing of this data will be subject to the requirements in the UK General Data Protection Regulations and the Data Protection Act 2018. Turning to new clause 65, this enables the independent reviewer of terrorism legislation to review and report on the use and operationalness, I don't think I said that right, the report on the use and how it's going of the youth diversion order. The independent reviewer already has a number of statutory functions, and this new clause aligns the independent reviewer's statutory functions, enabling him to report on the YDO. And the independent reviewer has been consulted on this clause, and his view is that the power to review the operation of the youth diversion order is an important one. Now, turning to new clause 42 put forward by the Shadow Minister, This would require the government to publish a report on the organisations responsible for implementing and enforcing YDOs, a plan for delivering the relevant funding, training and guidance available for these organisations, as well as requiring the government to commission a report from the Independent Reviewer of Terrorism Legislation. As Matt Dukes, the head of counter-terrorism policing, set out in his written evidence to this committee, counter-terrorism policing are a collaboration of UK police forces with a network of exceptional investigators. They are the lead law enforcement agency for managing terror risk, so it is appropriate that the implementation and enforcement of YDOs will be led by them. They will be supported in this role by youth justice partners who will have substantial experience in working with young people who are subject to court-imposed orders. As I've already set out, Government New Clause 65 already ensures that YDOs are added to the statutory remit of the Independent Reviewer of Terrorism Legislation. As part of this role, the Independent Reviewer is required to review the operation of YDOs in practice and report to Parliament. I hope that the Shadow Minister agrees with me that New Clause 42 is therefore unnecessary, and I commend the Government's amendments to the committee. I just want to refer to about the other issue that the Honourable Gentleman referred to, which is about the consistent use of YDOs across the UK. And I think one of the key objectives of the statutory guidance under Clause 119 is that, which chief officers must have regard to, is to ensure that consistency actually happens. And also, just to go back on the point that was raised again about the youth offending teams, I think given the small size of the cohort of children likely to be given a YDO, we do not anticipate that the changes will be adding significant pressures to those youth offending teams. So I hope on the basis of that, I can commend the Government's amendments to the committee, and I beg to move.
Government Amendment 72 proposed to clause 118 as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye.
Aye.
To the contrary, no. I think the ayes have it. Government Amendments 73 to 75 to clause 118 have already been debated. With leave of the committee, I'll put a single question on those amendments and call the Minister to move the amendments. The question is that Government Amendments 73 to 75 to clause 118 be made. As many of that opinion say aye.
Aye.
If the contrary, no. I think the ayes have it. Clause 118 has just been debated. The question is that clause 118, as amended, stand part of the bill. As many of that opinion say aye.
Aye.
If the contrary, no. I think the ayes have it. We now come to Government Amendment 76 to clause 119, which has already been debated. I call the Minister to move the amendment formally. The question is that Government Amendment 76 to clause 119 be made. As many of that opinion say aye.
Aye.
If the contrary, no. I think the ayes have it. Clause 119 has just been debated. The question is that clause 119 as amended stand part of the bill. As many of that opinion say aye.
Aye.
If the contrary, no. I think the ayes have it. Clause 120 has also just been debated. The question is that clause 120 stand part of the bill. As many of that opinion say aye.
Aye.
If the contrary, no. I think the ayes have it. Government Amendments 77 and 78 to clause 121 have already been debated. With leave of the committee, I'll put a single question on those amendments. Call the Minister to move the amendments. The question is that Government Amendments 77 to 78 to clause 121 be made. As many of that opinion say aye.
Aye.
If the contrary, no. I think the ayes have it. Clause 121 has also just been debated. The question is that clause 121 as amended stand part of the bill. As many of that opinion say aye.
Aye.
If the contrary, no. I think the ayes have it. We now come to the question that clause 122 stand part of the bill. Minister.
Thank you, Mrs Lilbrook. Clause 122 amends the Terrorism Prevention and Investigation Measures Act 2011 and the National Security Act 2023 to broaden the definition of weapons that are prohibited for individuals subject to terrorism prevention and investigation measures or state threat prevention and investigation measures. The amendment gives the Secretary of State the power to prohibit possession of any item by individuals subject to terrorism prevention and investigation measures or state threat prevention and investigation measures, which she reasonably considers could be used to cause injury. This change builds on a recommendation by the Independent Reviewer of Terrorism Legislation, Jonathan Hall, KC, in his annual report on the Terrorism Acts in 2022. Under these proposals, not only will the Home Secretary have the power to prohibit the possession of any knife or bladed article for which prior approval has not been sought, she will also have the power to prohibit possession of any item which she reasonably considers could be used to cause injury, even where it has other legitimate uses. As the Independent Reviewer has said in his written submission to the Public Bill Committee, this power is needed. The modern threats we face, whether terrorism or state-directed, are as complex and diverse as ever. It is vital that we ensure our law enforcement and security partners have the tools they need to manage these threats. This amendment will ensure that our toolkit keeps pace with the evolving threat and supports our vital efforts to keep the British public safe. I beg to move.
Hear, hear.
The question is that clause 122 stand part of the bill. If any of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. We now come to the question that clause 123 stand part of the bill, with which it will be convenient to also consider new clause 43. Minister.
Section 13 of the Terrorism Act 2000 makes it an offence for a person to wear or display an article in such a way or in such circumstances as to arouse reasonable suspicion that they are a member or supporter of a prescribed terrorist organisation. The current offence is only committed if the person carries out this conduct in a public place. Clause 123 makes two key changes to Section 13. The first of these changes is to create a new offence where a person carries out the conduct in one of the relevant premises set out in the bill. These include prisons, young offender institutions and immigration removal centres. In 2022, the Independent Reviewer of Terrorism Legislation undertook a review of terrorism in prisons. This was within the context of the UK suffering 4 terrorist attacks in 2019 and 2020 committed by serving prisoners or terrorist offenders released on licence. One of the reviewer's recommendations was for the government to consider amending Section 13 to extend the offence to prison settings. This measure implements and builds on that recommendation. The new offence will act as a deterrent to this harmful conduct in the prison estate and help to prevent exposure to articles linked to terrorist organisations, which in turn may reduce the risk of individuals being radicalised or otherwise encouraged to support these groups. The second change made by Clause 123 concerns the powers of seizure under Section 13. In his report on the Terrorism Acts in 2022, the Independent Reviewer highlighted that the existing seizure powers would not be available where the police could not connect an article such as a flag or a banner to specific individuals for the purpose of further criminal investigation. He recommended that this gap should be rectified.
Yeah.
Clause 123 will therefore amend Section 13 to ensure the police can seize such articles even if there is no real prospect of prosecuting an individual for a Section 13 offence. It will mean an article may be seized to prevent its continuing display as well as to preserve it as evidence. Both changes to Section 13 of the Terrorism Act 2000 implement the Independent Reviewer's recommendations and are supported by the police. They will ensure that the offence and associated seizure powers can be used to full effect. I'm happy to refer to new clause or to respond to new clause 43. I think when we've heard from the Shadow Minister.
Clause 123 amends Section 13 of the Terrorism Act 2000, which concerns the offence of wearing or displaying articles in support of a prescribed organisation. The key amendment introduces a new offence where a person commits an offence if, on relevant premises, they wear an item of clothing or display an article that arouses reasonable suspicion that they're a member or supporter of a prescribed organisation. What is the rationale for introducing the concept of reasonable suspicion in the offence of wearing or displaying articles, as opposed to requiring more direct evidence of support for a prescribed organisation? I'd also be grateful for any clarity on how the list of relevant premises is determined, and could this include other locations or contexts beyond those listed? New clause 43 introduces a criminal offence for individuals who travel outside of the United Kingdom to support a prescribed organisation. The offence covers various forms of support, including joining or working for a prescribed organisation or its affiliated groups, attending events in support of such an organisation, meeting with its members, creating content to promote the organisation, or travelling to areas controlled by the organisation without a legal exemption. The clause provides specific exemptions for accredited non-governmental organisations and humanitarian organisations, media outlets and journalists, and diplomats or government officials travelling in an official capacity. A person found guilty under this provision could face a severe penalty, imprisonment for up to 14 years on conviction on indictment, or up to 6 months and a fine on summary conviction. This measure is a proactive step in curbing the influence and spread of terrorism. By criminalising travel abroad to support a prescribed organisation, it helps prevent individuals from engaging in activities that might contribute to terrorism and destabilisation abroad. The inclusion of various forms of support, ranging from membership and financial involvement to attending gatherings or creating content, provides clarity on what constitutes illegal activity. This ensures that law enforcement can pursue a wide range of actions that supported prescribed organisations. New clause 43 is designed to prevent individuals from becoming embedded with or supporting prescribed organisations. Why would the government not support a preventative measure that helps protect the UK from individuals travelling abroad to engage in terrorism-related activities?
Minister.
So, as the Honourable Member for Stockton West has explained, new clause 43 seeks to introduce a new offence for travelling abroad to support a prescribed organisation. Now, the UK has one of the strongest counter-terrorism frameworks in the world. This includes, under the Terrorism Act 2000, the ability to prescribe an organisation which the Home Secretary reasonably believes is concerned in terrorism. This means it commits and participates in terrorism, it prepares for terrorism, it promotes or encourages terrorism, or is otherwise concerned in terrorism. And some 80 terrorist organisations are currently prescribed. As part of the counter-terrorism framework, there are a wide range of powers and offences that can be used by the government and operational partners to disrupt travel overseas for terrorist purposes and to prosecute individuals on their return. This includes, for example, an executive power to cancel a British citizen's passport and the power to temporarily seize a passport when there is a reasonable suspicion that the person is travelling to engage in terrorism-related activity. There is also a wide range of terrorism offences which could be engaged in relation to an individual who travels to support a prescribed organisation. For example, it is an offence, obviously, to be a member of a prescribed organisation, to invite support for a prescribed organisation. The invited support can be intangible and is not limited to money or property or support that incites violence or encourages terrorism. To attend a place used for terrorist training, or to provide or receive terrorist training, and to undertake preparatory acts with the intention of committing an act of terrorism or assisting another to commit an act of terrorism. The counter-terrorism framework also includes the designated area offence, which permits the Secretary of State to designate an area if she is satisfied that it is necessary for the purposes of protecting members of the public from a risk of terrorism, to restrict British nationals and residents from entering or remaining in the area. It is an offence for UK nationals or UK residents to enter or remain in a designated area. And I recognise that this power has not been used to date, but the government's view is that it remains a useful tool to disrupt terrorist travel in the right circumstances. And as the Shadow Minister may be aware, the government is currently considering a recommendation made by the independent reviewer of terrorism legislation, Jonathan Hall KC, on this very topic raised by his amendment. So the government will not hesitate to address gaps in our toolkit and ensure it keeps pace with the modern terrorist threat. We've brought forward measures in the bill implementing and building on recommendations that the reviewer has put forward under the last government. In November 24, the Home Secretary accepted Jonathan Hall's recommendations to consider introducing a new terrorist travel offence. Officials are currently considering this with operational partners and the extent to which there is a gap. It's vital that any new offence extends operational partners and the CPS's ability to disrupt and prosecute those involved in terrorism, disrupting terrorist travel, and the government will respond fully to that recommendation in due course. Just before I conclude, the issue around reasonable suspicion and the requirement, this measure simply extends beyond private settings to those designated settings. We're not changing the reasonable suspicion test. I hope that's helpful to the Shadow Minister. And for the reasons set out, I hope that the Shadow Minister will be content not to move his new clause 43 when it's reached later in our proceedings.
Question is that clause 123 stand part of the bill. As many are of that opinion, say aye.
Aye.
Of the contrary, no. I think the ayes have it. We now come to the question that clause 124 stand part of the bill, with which it will be convenient to also consider Schedule 16, Government New Clause 21 and Government Amendment 23. Minister.
Thank you, Mrs Lilbuck. Clause 124 introduces Schedule 16 to the bill, which amends the Counter-Terrorism Act of 2008. This gives powers to effectively manage a certain cohort of historic terrorism offenders. This cohort includes individuals who committed non-terrorism offences, such as conspiracy to murder, that would have been considered to have a terrorism connection had they not committed their offence before the relevant legislation came into effect. This is the same cohort of historic terrorism-connected offenders as captured by Clause 104 related to polygraph testing of those offenders, which my honourable friend spoke to earlier on. The Counter-Terrorism Act 2008 introduced a requirement for courts to consider whether there is a connection to terrorism when sentencing certain specified offences. In circumstances where a court determines that an offence has a terrorism connection, it must aggravate the sentence. Where a terrorist connection is determined, the sentence imposed will reflect the high risk of the risk profile of the offender. In addition, the offender can be more appropriately managed on their release because certain counter-terrorism risk management tools become available to the police in respect of that offender. Since the passage of the 2008 Act, several further risk management tools have been introduced to manage terrorism and terrorist-connected offenders via various Acts of Parliament. The Counter-Terrorism and Sentencing Act 2021 also expanded the scope of the terrorist connection provisions to require a court to aggravate certain non-terrorism offences with a maximum penalty of more than 2 years. This clause and associated schedule will extend the application of existing risk management measures. These measures include powers of urgent arrest and personal search for those on licence where it is suspected that they have breached a licence condition, as well as imposing terrorist notification requirements under the 2000 Act for this cohort of historic terrorism-connected offenders. The Independent Reviewer of Terrorism Legislation noted that this new schedule will allow the police to apply important counter-terrorism measures to serious offenders involved in terrorist plots backed by prescribed organisations but who were convicted of non-terrorism offences. The amendments made in Schedule 16 will also permit the police or the Secretary of State to apply to the courts for an order imposing the terrorist notification requirements on offenders whose historical offences have a terrorist connection. If such an order is made, the urgent arrest power and the power of personal search will also apply in respect of the offender. This measure is supported by the police and the Independent Reviewer of Terrorism Legislation, with the reviewer describing it as a sensible measure. Turning now to Government New Clause 21, this seeks to add certain existing terrorism-related offences to Schedule 4 to the Modern Slavery Act 2015. Government Amendment 23 is consequential on New Clause 21. As we've previously debated, Schedule 4 to the 2015 Act contains a list of serious offences to which the Section 45 defence of that Act does not apply. The list currently includes some terrorism offences, as well as serious violence and sexual offences. Section 45 provides a statutory defence against prosecution for victims of modern slavery and is designed to give victims the confidence to come forward without fear of prosecution. Schedule 4 to the 2015 Act ensures that those who commit the most serious offences specified in that schedule do not have the option to rely on this defence. New Clause 21 would add existing terrorism offences to Schedule 4, building on a recommendation made by the Independent Reviewer of Terrorism Legislation. Currently, only a limited number of terrorism offences are listed in Schedule 4, including those in Sections 5 and 6 of the Terrorism Act 2006, the preparation of terrorist acts and the training for terrorism, respectively, while others, such as that in Section 58 of the Terrorism Act 2000, the collection of information useful to terrorists, are in scope of the Section 45 defence. In his 2021 report, the Independent Reviewer of Terrorism Legislation set out his concerns about the operation of the Section 45 defence in the context of counter-terrorism investigations. The report suggested that all terrorism offences are sufficiently serious to warrant an exemption from the Section 45 defence. It also stressed that this change would simplify cases where numerous terrorism offences are being prosecuted together, ensuring prosecutorial consistency. We agree with the Independent Review's recommendation and have decided that Schedule 4 should include all those terrorism offences within scope of the Terrorist Offenders Restriction of Early Release Act 2020. These offences carry a minimum sentence of 2 years in duration with associated terrorist offender notification requirements. These amendments are supported by counter-terrorism policing and the Crown Prosecution Service. Given the clear operational need for these amendments in supporting public safety, I trust that the Honourable Member will support new clause 21.
Question is that clause 124 stand part of the bill. As many are of that opinion, say aye.
Aye.
Of the contrary, no. I think the ayes have it. We now put the question that clause 125 stand part of the bill, with which it will be also convenient to consider Schedule 17. Minister.
Thank you, Madam Chair. Clause 125 will bring the offence of breaching a foreign travel restriction order under paragraph 15 of the Schedule 5 to the Counter-Terrorism Act 2008 within scope of the Terrorist Offenders Restriction of Early Release Act 2020, known as TORA. TORA was emergency legislation passed in 2020 following the horrific terrorist attacks at Fishmongers Hall and in Streatham committed by terrorist offenders on licence. TORA restricts eligibility for release on licence of terrorist prisoners. It ended the automatic, i.e. without parole board approval, early release of individuals who committed a terrorist offence carrying a maximum penalty of more than 2 years imprisonment, and increased their release eligibility date from the halfway point of their sentence to the 2/3 point. The offence of breaching a foreign travel restriction order is not currently covered by TORA, despite having a maximum penalty of 5 years imprisonment, being a terrorism-specific offence, and offences for breaching other terrorism-related orders being within scope of TORA. This amendment will add breaching a foreign travel restriction order to TORA, ensuring greater consistency. Since the introduction of TORA in 2020, there have been a number of other changes made to the counter-terrorism legislative framework to strengthen the risk management of individuals who commit a terrorism offence carrying a maximum penalty of more than 2 years. We are seeking to apply these changes to this offence too in order to ensure that consistency remains. Specifically, ensuring that the offence of breaching a foreign travel restriction order is capable of attracting a sentence for offenders of particular concern and the equivalent sentence in Northern Ireland and Scotland. Making the offender eligible for certain specialist management on licence, including eligibility for personal search conditions, which will be UK-wide, and the polygraph condition, which is for England and Wales only. And that the offence is incapable of being found by the court at the point of sentencing to have been committed with a terrorist connection on the basis that it is in fact a terrorist offence. Now, given the offence of breaching a foreign travel restriction order applies UK-wide, the clause also makes the equivalent changes for Scotland and Northern Ireland. This change will ensure sentencing and the release arrangements are commensurate with the risk that the individual is considered to pose, and will ensure eligibility for the terrorism management conditions consistent with other terrorist offenders. I commend Clause 125 and Schedule 7 to the committee.
Question is that Clause 125 stand part of the bill. As many are of that opinion, say aye.
Aye.
The contrary, no. I think the ayes have it. We now come to the question that Clause 126 stand part of the bill. Minister.
Chair, Clause 126 represents a minor amendment to ensure that sentencing for terrorist offenders in Northern Ireland remains consistent with England and Wales. The sentencing and release regime for terrorists who commit offences attracting a maximum penalty of over 2 years' imprisonment is designed to be consistent throughout the United Kingdom. However, as currently drafted, the relevant legislation in Northern Ireland, namely the Criminal Justice Northern Ireland Order 2008, and Article 15A specifically, makes it possible for judges to hand down incommensurate sentences under this provision. The purpose of this amendment is to ensure consistency, making sure that where a sentencing court in Northern Ireland hands down this type of sentence, known as the terrorism sentence with a fixed licence period, the length of the sentence must be commensurate with the seriousness of the offending. This will then be comparable to the equivalent sentence in England and Wales, namely the sentence for offenders of particular concern. Action is necessary to ensure consistency and fairness across UK jurisdictions, and I commend Clause 126 to the committee.
Yeah.
Question is that Clause 126 stand part of the bill. As many of that opinion, say aye.
Aye.
Of the contrary, no. I think the ayes have it. Schedule 16 has already been debated with Clause 124. The question is that Schedule 16 be the 16th schedule of the bill. As many of that opinion, say aye.
Aye.
Of the contrary, no. I think the ayes have it. Schedule 17 has also already been debated with Clause 125. The question is that Schedule 17 be the 17th schedule to the bill. As many of that opinion, say aye.
Aye.
The contrary, no. I think the ayes have it. We now come to the question that Clause 127 stand part of the bill, which it will be convenient to also consider Clauses 128 and 129 stand part. Minister.
Thank you, Mrs. Lawbrook. Clause 127 is around the implementation of international law enforcement information sharing agreements. Clause 128 sets out the meaning of appropriate national authority, and Clause 129 is based on the consultation with devolved authorities about regulations under Clause 127. International law enforcement information sharing agreements are a vital tool that provide law enforcement officers with access to new intelligence to fight crime, increase public protection and reduce the threat of societal harm posed by international criminality. So Clause 127 will provide the appropriate national authority with the power to make regulations to implement any new legally binding international law enforcement information sharing agreements. Such regulations may, for example, make provision for the technical and, where appropriate, operational detail to facilitate the information sharing provided for in a particular agreement. Clause 127 also stipulates that regulations can only be made in connection with implementing an international agreement insofar as it relates to the sharing of information for law enforcement purposes, and that any data sharing must comply with data protection legislation. Clause 128 defines the appropriate national authority as the Secretary of State, or where a provision falls within devolved competence, Scottish ministers, Welsh ministers, or the Northern Ireland Department of Justice. Clause 129 requires the Secretary of State to consult devolved governments before making regulations about any provisions within the regulations which would be within the legislative competence of the relevant devolved legislature. These measures will enable the swift implementation of new international agreements that are designed to help keep the public safe from the threat posed by international criminality and cross-border crime, and help protect vulnerable people. And I beg to move.
Matt Vickers.
Clause 127 gives the Government the power to make regulations to implement international agreements related to the sharing of law enforcement information. These agreements may evolve over time, and the clause ensures that the UK law can adapt accordingly. This clause allows regulations to override existing restrictions on information sharing, but with two key safeguards. Data protection safeguard: regulations cannot require or allow the processing of personal data in a way that would breach UK data protection laws unless the regulations themselves impose a legal duty or power. And regulations cannot override the restrictions set out in the Investigatory Powers Act 2016, which covers surveillance and interception of communications. This clause aims to ensure the UK can meet its obligations under international law enforcement agreements while still upholding important privacy and legal protections. Clause 128 defines who the appropriate national authority is for the purposes of making regulations under Clause 127, which concerns implementing international information sharing agreements for law enforcement. Clause 129 places a duty on the Secretary of State to consult the devolved administrations before making any regulations under Clause 127 that include provisions falling within the legislative competence of a devolved legislature as set out in Clause 128. This ensures proper engagement and respect for the roles of the Scottish Government, Welsh Government and Northern Ireland Executive when regulations touch on devolved matters. We welcome these measures. I wonder if the Minister could briefly comment on what format such consultation would take.
I'm happy to comment, and obviously with matters like this, the normal procedures that are in place around consultation fit in, and I know that there's been extensive consultation in terms of getting these provisions into the bill. So with that, they are just the normal ways that we consult, and I hope that that satisfies the Shadow Minister.
The question is that Clause 127 stand part of the bill. As many are of that opinion, say aye.
Aye.
The contrary, no. I think the ayes have it. Clauses 128 and 129 have just been debated. With the leave of the committee, I will put a single question on those clauses. The question is that clauses 128 and 129 stand part of the bill. As many of that opinion, say aye.
Aye.
If the contrary, no. I think the ayes have it. We now come to the question that clause 130 stand part of the bill. Minister.
Thank you, Mrs Lilbrook. Clause 130, crimes can be committed by corporate bodies, as we know, just as they can be committed by individuals, and it's important that corporate bodies are held liable for committing criminality and face justice accordingly, and this is achieved through what's called the identification doctrine. In the 1970s, the Tesco and Natras case determined that a corporation can be held liable for a crime if it is committed by their directing mind and will. However, there is a lack of clarity on what constitutes that directing mind and will. As companies have grown in size and complexity, there are often multiple controlling minds within different business functions who can exert control and cause harm through different functions of the business. Through Clause 130, the Government is placing the case law test for attributing crimes to corporate bodies on a statutory footing and clarifying and extending the circumstances under which a body corporate or partnership is liable for any criminal offence if that offence has been committed by their senior management. The previous government made the first stage of this reform in the Economic Crime and Corporate Transparency Act 2023, placing the identification doctrine in legislation for economic crime offences. However, the identification doctrine was never intended as an economic crime only regime. It has historically applied to any criminal offence in case law, and it is important that statute reflects this. Clause 130 therefore repeals the relevant sections of the 23 Act and replaces it with an identification doctrine that applies to all relevant crime, not just economic crime. As a result of this clause, a body corporate or partnership in the UK can be held liable for any criminal offence and fined accordingly, where a senior manager who has control over the whole or a substantial part of the business commits an offence while acting in the scope of their actual or apparent authority. The broadening of the principle to senior managers with control over any substantial part of the body corporate reflects the wide decision-making responsibility of organisations and mitigates prior concerns that individuals committing crime could escape liability by changing or removing their title. This will ensure businesses cannot continue to avoid liability where their senior management have clearly used the business to facilitate or conducted crime. I beg to move.
Figures.
Clause 130 holds organisations criminally liable when a senior manager commits an offence within their authority, expanding liability beyond economic crimes to all criminal offences. This reform addresses gaps in the previous identification doctrine and applies to both UK and non-UK entities. However, liability won't apply if the offences occur entirely outside the UK, unless it would be criminal at the corporate level in the UK. Could I ask the Minister how the Government will ensure that the broader application of corporate liability strikes the right balance between holding organisations accountable and avoiding unfair penalisation for offences that occur in part outside the UK?
Minister.
Well, I'm grateful for that question in terms of if it's quite clear that offences that are committed outside the UK would not be covered by this. I think that answers the Shadow Minister's question, and that's clearly something that we need to keep under review, because I know there's other legislation where it does have extra territorial application, but I'm certainly willing to go away and look at that and come back to him on that point.
The question is that clause 130 stand part of the bill. As many of that opinion say aye.
Aye.
The contrary, no. I think the ayes have it.
Madam Chair, I beg to move the motion in my name on the amendment paper, amending the programme order of Thursday the 27th of March.
Amendment proposed to leave out paragraph 1G. The question is that the amendment be made. The question is that the amendment to the programme order be made. As many of that opinion say aye.
Aye.
The contrary, no. I think the ayes have it.
Madam Chair, I beg to move that this committee do now adjourn.
The question is that further consideration of the bill be now adjourned. As many of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. Order. Order.
Room 11, sound. Committee Room 11, sound. Committee Room 11, sound. Committee Room 11, sound.